Good morning, everyone. The hour has reached 12 o'clock p.m. Eastern Time. I would like to welcome you all to our July 12th, 2024 public briefing of the North Carolina Advisory Committee to the United States Commission on Civil Rights. I am Olga Morgan Wright, Chair of the committee. Before we get started, I would like to remind everyone that this meeting is being recorded. I will begin with roll call. Daniel Bose.
Present.
Thank you. Pearl Floyd, not here. Sorry, my screen is gone. All right, let's see. Can you all still hear me?
Yes.
Yes, we can hear
Okay,
you.
thank you. I'm not on the screen, but that's okay. I'll keep moving forward. I'm Travis Cook. Christopher Duggan.
Present.
Thank you. Marcus Gatson. Stephen Green. Jonathan Guzet. Jennifer Lechner. Can you all still hear me?
Yes.
Okay, I'm sorry, because I can't see anything right now. Angelo Mathey. Patrick Mincy. Donna Oldham.
Here.
Thank you. Catherine Reed. Mercedes Restucha.
Here.
Thank you. Gregory Wallace.
Here.
Thank you. The United
Madam
States.
Chairman, I think I might have been muted. This is John Gusay. I'm here.
Thank you. Thank you very much. The United States Commission on Civil Rights is an independent bipartisan agency of the federal government charged with studying discrimination or denial of equal protection of the laws. In all 50 states, the District of Columbia, and the U.S. territories, an advisory committee to the commission has been established, and they are made up of responsible persons who serve without compensation to advise the commission on relevant information concerning their respective jurisdictions. Today is our first panel where we will hear testimony from researchers and academics on the implementation of Ryan's Law and its civil rights effects on the child welfare system in North Carolina. Given that we have a lot to cover today, and out of respect to our guests, I want to note that we will abide strictly to our agenda. Panelists have 10 to 12 minutes for prepared remarks. I will provide each panelist a 2-minute warning when their time is almost up. After each panelist has presented, we will begin our Q&A session. I will use the roll call list to give committee members a chance to speak. Committee members are limited to one question and a follow-up each, and as time allows, I will circle back for a second round of questioning. Committee members are asked to focus on a question and not share comments or their own opinion on the topic. Members of the public have up to 3 minutes for their comment. Members of the public should kindly note that the public comment section is intended for remarks on our study and is not meant to be a Q&A with committee members or panelists. A timer will be made visible on the screen so that speakers will know how long they have. Speakers will be notified when their time is up. I reserve the right to provide warnings if a speaker is over time and ask staff to mute the speaker. We ask that everyone respect the time allotted and end their remarks when the 3 minutes run out, as to give others a chance to speak. We will need to give a verbal 1-minute warning for any public commenters joining by phone, as they are not able to see the timer. For all participants, if for any reason it would be helpful for us to provide you a 1-minute verbal warning, please let us know when we call your name. Though some of the statements made today may be controversial, we want to ensure that all guests today do not defame or degrade any person or organization. If a specific person or organization is named in a potentially defamatory manner, they will be provided an opportunity to respond, and this response will be a part of the public record. As the chair, I reserve the privilege to cut short any statements that defame, degrade, or do not pertain to the issue at hand via the following process. 1, I will remind the commenter that we do not accept defamatory, degrading comment, and I will reach out to the impacted person for a response. 2, if the statement continues in the same manner, I will give the person a warning that we will hard mute them if they continue. And 3, the commenter may be hard muted if needed. Based on these proceedings, the committee will prepare a report to the United States Commission on Civil Rights detailing findings and recommendations for addressing this issue of national importance. The draft will be available for public review, and we are grateful to all speakers for their willingness to share their experiences with us today. At the onset, I want to remind everyone present of the ground rules. This is a public meeting, and remarks will be recorded and transcribed for the public record. We have a very full schedule with limited time. After hearing from all participants today, committee members will be called on by the chair using the roll call list. After everyone has had a chance to ask a question, I will ask if anyone has additional questions. Committee members are asked to use the raise hand function in Zoom to express their interest in asking a question of one or all panelists. I will call on committee members in the order that their hand was raised. To accommodate persons who are not on the agenda but wish to make comments, we will ask for public comments toward the end of today's meeting. We ask that you raise your hand in Zoom, and I will call on individuals in that order. The raise hand function can be found by clicking on the reactions icon at the bottom of your Zoom screen. You will be unmuted by staff so that you can speak. 3 minutes will be allowed per speaker. And again, we kindly remind you to use this space for comments only, not Q&A. Please note that we are required to obtain the legal names of anyone providing public comment. As required by the Federal Advisory Committee Act and its regulations, 41 CFR 102-3.165, as chair, I must ensure that detailed minutes of meetings are kept, and those minutes must include a list of persons who are present at the meeting, including members of the public who present oral or written comment. Please contact staff at lscher@usccr.gov if there is an error in your name and you need it to appear correctly in the public record for today's meeting. In addition, written statements related to today's briefing may be submitted by September 23rd, 2024 to Liliana Schiller at lschiller@usccr.gov for inclusion in the public record. Today, we are scheduled to hear from 4 panelists. Once all the panelists have finished their testimonies, we will have a Q&A session. Panelists are invited to stay for the remainder of the meeting as long as able. Our first panelist, Laura Matthews Jolly. Professor Laura Matthews Jolly is our first speaker today. She is an assistant professor of law at North Carolina Central University School of Law. Professor Matthews Jolly, you have the floor.
Good afternoon, and thank you for inviting me to speak today. I am a professor at North Carolina Central University School of Law. Prior to entering academia, I practiced public interest law for more than a decade. My legal background includes the unique experience of representing both children and parents in abuse, neglect, and dependency proceedings. This dual perspective informs my research on families impacted by the system that has traditionally been referred to as the child welfare or child protective system, but which is now more regularly acknowledged as the family regulation or family policing system. For the last year, my research has centered on visitation between parents and their children placed in the foster system. My testimony today will address how Rylan's law, which was enacted in 2017 and revised in 2021, changed North Carolina's visitation law and has affected family reunification rates. Why does visitation matter? To start, the fundamental right to family integrity has been enshrined in Supreme Court precedent for more than a century. More than that, it is inescapably true that the less a parent and child interact, the less likely they will be able to maintain their relationship. Relying on extensive social science research, the U.S. Department of Health and Human Services has issued guidance stating that frequent, meaningful visitation between parents and their children placed in the foster system is the single best predictor of safe and lasting reunification. Frequent, meaningful visitation reduces the amount of time children spend in the system, increases the likelihood of family reunification being both achieved and sustained, and results in multiple positive outcomes for children even when family reunification will not occur. The American Association of Pediatrics has explained that family separation can cause irreparable harm, disrupting a child's brain architecture and affecting his or her short and long-term health, and further states that weekly or other sporadic visits stretch the bounds of a young child's sense of time and do not allow for a psychologically meaningful relationship. Under Rylan's law, the default visitation norm between parents and their children placed in the foster system in North Carolina is 1 visit per week for 1 hour and supervised by DSS. This amounts to 52 hours, or roughly 2 days of time together in an entire year. Too frequently, the site of these visits is a sterile, unnatural room where the parent and child are being observed by a state employee taking notes. Pursuant to Rylan's law, before DSS may recommend unsupervised visits, DSS must observe 2 visits conducted 7 days apart within 30 days of a hearing at which DSS anticipates making a recommendation for unsupervised visitation. Practitioners report that DSS will only begin to consider unsupervised visitation 6 to 8 months into a case. Parents must prove that they are compliant and worthy of meaningful contact with their child. Even then, staffing shortages and limited resources challenge the department's ability to conduct the visits pursuant to Rylan's law. For a system ostensibly designed to strengthen families and promote the well-being of children, we should be outraged by these default norms. According to your committee, only 30% of the 5,000 children who left North Carolina's foster system in the 2022-23 fiscal year were reunited with their parents. Durham County's reunification rate of 22% is less than half the national average. These statistics are shocking when considering that federal and state law presume family reunification serves children's best interests, and when receipt of federal money expects states to work with families to develop individualized case plans that aid rehabilitation and reunification. Next, I use a case to illustrate the implementation of visitation law. This case, matter of TRB, comes from Alamance County, and the court opinion refers to the child by the pseudonym Tim. DSS filed a petition against Tim's mother when Tim was 2 days old. There's no mention of any imminent safety risk to Tim remaining in his mother's care. The basis for Tim's case appears solely due to Tim's older siblings being adjudicated as neglectful 3 years prior to Tim's birth. Tim's mother was to complete a laundry list of services, and Tim and his mother were provided 1 supervised visit per week. At a permanency hearing, when Tim was 1.5 years, both DSS and the GAL moved to restrict visitation. And I want to take a moment here to highlight the evidence presented and the arguments made by DSS and the GAL. The DSS caseworker testified to the numerous items that Tim's mother brought to each visit, including microwavable meals, diapers, and wipes. The DSS caseworker testified that Tim's mother interacted with her son during the visits and that there were no problems during visits. However, the DSS caseworker then went on to claim that Tim's mother's ability to do things in that visitation room is not real life. She stated that she had concerns about Tim's mother's ability to protect him in a community setting. The GAL advocate then testified that she is still concerned about Tim's mother's ability to meet Tim's needs. The judge granted the request of DSS and the GAL and restricted this family's contact from once a week to once every other week. This case is illustrative of several realities facing North Carolina families in these court proceedings. I want to address 3 of them. First, default visitation norms in this state not only curtail a family's ability to be a family, but also, when implemented in a restrictive way, forestall a parent's ability to perform the very act that is required of them, parenting. Parents face this perpetual catch-22, where the system demands performance of the ability to parent, yet denies parents the opportunity to perform. In doing so, the de minimis contact provided to the separated family then becomes evidence upon which the court relies to determine that a parent lacks the ability to parent. Second, restricting family contact should only occur when there is a demonstrated acute risk of harm to a child. Too many determinations about whether families can be together are based on vague, hypothetical concerns that lack evidence of a safety risk. Tim's mother, who suffered from post-traumatic stress disorder, had not completed her laundry list of services. The trial court found, for example, that Tim's mother still needed counseling for her trauma, that she was a no-show for 1 single therapy session, yet lacking in the arguments of DSS and the GAL, as well as the court's opinion, was any analysis of what, if any, impact these outstanding services had on Tim and his mother's visitation. Family time should only be restricted if the incompletion of services creates a safety risk for the child. No safety risk is mentioned in this case. Federal guidance asserts that visitation should never be reduced solely due to a parent's non-compliance with a case plan, and further, that restricting visitation as a form of punishment for a parent's non-compliance harms children. Third, I encourage you to think critically about the role of a GAL. For a year and a half, Tim had weekly supervised contact with his mother. No concerns were raised about this contact. Quite the opposite. Tim's mother came prepared with food and diapers. She interacted well with him during these visits. How was this 1.5-year-old's best interest served by limiting his contact with his mom from once a week to once every other week? What was the basis for the GAL's position that this 1.5-year-old should have less contact with his mother? Certainly, this 1.5-year-old did not verbalize that position. GALs carry tremendous power in the courtroom and often wield unfettered discretion in the positions that they take on behalf of children. Yet GALs are not neutral observers, and research indicates that discretion invites bias, even if that bias is unintentional, and even if that advocate came to this work truly wanting to help children. Too often, GALs seek to limit family time based on perceived or observed negative responses from a child. Yet federal guidance tells us that children may display a range of emotions surrounding visitation with their parent.
Professor, this is your 2-minute warning.
Thank you. Such responses like behavioral outburst, crying, sleep disturbances, may actually mean that a child has a secure attachment with their parent and needs more contact, not less. Rylan tragically drowned in a pond near his home while in the care of his mother. Yet we should not make systemic changes that harm more than help families based on this outlier case. Imagine, as a thought experiment, that parents and their children placed in North Carolina's foster system spent time together in ways that comport with each family's routines, preferences, and values. Some families who are temporarily separated by the state would attend church together on Sunday mornings. Other families would walk to and from school together. Depending on the family, contact might revolve around meals, bedtime, hair care, holidays, birthdays, medical appointments. This type of contact would reflect what it is and means to be a family. Other states have actively taken steps to make this thought experiment a reality, and during the Q&A, I'd be more than happy to share examples from other states. To conclude, as I hope my testimony has demonstrated, it is a false choice between expanding parent-child contact and keeping children safe. It is a false choice between preserving families and keeping children safe. Communities and families actually do keep children safe. I strongly encourage North Carolina to invest in the very communities where children are being removed. We have a myriad of ways outside of this system to provide true safety for children. And I know I'm at the end of my time, so I look forward to answering any questions you may have during the Q&A. Thank you.
Thank you very much for your remarks. Now we will hear from Professor Emily Putnam-Hornstein. I hope I didn't mispronounce her name. She is a John A. Tate Distinguished Professor for Children in Need at the School of Social Work at the University of North Carolina at Chapel Hill and Faculty Co-Director of the Children's Data Network. Professor Putnam-Hornstein, you have the floor.
Terrific, thank you. And you got my name just right, so no worries there. Thank you for the opportunity to offer testimony today. You've seen my bio. For 2 decades, I've worked closely with child protection agencies, and my research has focused on the use of data to better understand which children are reported for maltreatment and how we can adopt tools, technologies, and practices that help us improve child safety. The testimony I will offer today was developed based on my review of data from North Carolina's Child Welfare Management Assistance Reports, which are hosted at UNC Chapel Hill, federal child maltreatment and foster care reports, local media coverage and commentaries from the last several years, and reviews of vital records and other information released from the North Carolina Department of Health and Human Services. I've done my best to accurately report the data I could find and would welcome follow-up if I've gotten anything wrong. All data I reference is public. In an effort to tailor my remarks to what I understand to be the most salient questions of this committee, I listened to all recordings starting with the November 9th meeting. I also joined the community meeting on June 27th. Before I begin, I want to surface the powerful words of the very last speaker at that evening community meeting, who said, quote, "My remarks are not meant to negate any of the testimony shared before me." She also noted that we do need reform and we need accountability. I feel the same. That speaker, however, as the sole individual who spoke of her experiences of child maltreatment and the associated trauma following repeated failed reunifications, asked that we, quote, "not forget those of us who are vulnerable to unsafe parents," which of course is why Rylan's law was passed. We returned a toddler to a parent who was simply incapable of caring for him, and he died. For the remainder of my time, I will present data I hope is responsive to the committee's decision to examine the civil rights effects of the implementation of HB 630, Rylan's law in North Carolina. But I would note that the law itself was crafted not because of civil rights concerns of parents, but because we failed in our obligation to protect a 1-year-old boy and an unknown number of other children. Professor Jolly in her remarks implied that Rylan's law is hurting both children and families. I think that is a question that bears closer examination, and I hope some of the data I present will be helpful. First, over time, and especially since Rylan's Law, are more children in North Carolina being investigated for abuse or neglect? No. The number of children investigated for maltreatment has consistently declined in North Carolina, from a peak of 68,000 in 2011 to 54,000 in 2022-2023, a 26% decline. Since the passage of Rylan's Law, investigations have declined by 16%. There were no notable changes in the size of the child population during this period, so the rates of children investigated per 1,000 have also dropped. Is this a good thing? Certainly, if you choose to refer to our child protection system as a family regulation or family policing system, perhaps we have fewer children who are investigated. But I would argue it is only a good thing if we have successfully reduced the number of children who are experiencing abuse and neglect. While we talk about allegations of neglect, most cases of maltreatment, in fact, involve one or more concerns of serious parental substance use, mental health concerns, or domestic violence. And since we find ourselves in the midst of a drug epidemic that is ravaging the adult community, it does seem counterintuitive that fewer children need protection. One thing that did catch my attention in examining data for the state is that there has been a 20% increase, admittedly one that long predates Rylan's Law, I went back 20 years, in children who are experiencing a repeat investigation rather than a first investigation. To me, that suggests we're leaving more children in situations where maltreatment may be ongoing, so that on any given day in North Carolina, more children are investigated for abuse or neglect who have been previously investigated for abuse or neglect. We thought they could remain safely at home, but future allegations call that decision into question. Second, over time, and especially since Rylan's Law, are more children in North Carolina being substantiated or confirmed as victims of abuse or neglect? Again, the answer is no. The number of recorded victims has declined overall and as a share of children investigated, as has the rate of substantiated child victims in the population overall. It's good. Fewer child abuse and neglect victims. Again, I would argue it is good if we believe we have successfully reduced the number of children who are experiencing abuse and neglect and who either need services or protection. But of course, there are other ways a state can reduce the number of children who are substantiated. We can simply change the threshold for when we classify a child as a victim following an investigation. Intuitively, if North Carolina had been investigating far more children for abuse and neglect than was warranted prior to Rylan's laws and going back over time, one would expect that as more low-risk referrals are screened out and diverted, the pool of children who remain and who are investigated would be distinctively higher risk, such that a greater share of those investigated cases would lead to substantiation and perhaps necessitate foster care. Yet that is not what the data show. The share of children who are substantiated among those investigated has declined by 19%, almost exactly the decline observed for investigations overall. Third, are there racial differences in who is investigated for abuse or neglect in North Carolina? Based on the most recent data I could identify, it looks as if between July 2022 and June 2023, roughly 3.5% of Black children in North Carolina experienced an investigation for abuse or neglect, versus 2.1% of Hispanic children and 2.3% of white children. I did not find any notable changes in the racial distribution of children who are investigated for maltreatment since the passage of Rylan's Law, other than a modest shift away from children who are classified as white to those whose race is recorded as other. This was accompanied by a slight increase in the share of children who were classified as of Hispanic ethnicity. The share of investigations involving Black children has remained fairly constant at roughly 1/3. Fourth, What about children in foster care? Have those numbers increased or decreased in recent years? To answer this question, it's important to remember that the number of children in foster care in North Carolina on any given day is a function of how many children have entered that year relative to how many children have exited. Among children who are investigated for maltreatment, we see slight reductions in entries to foster care over time and dating back to before the implementation of Rylan's law. When we look at a point-in-time snapshot of where children are placed in foster care, we see very significant reductions in the use of non-family foster care settings. Back in the late 90s and early 2000s, close to a quarter of children in foster care were in non-family settings. This is down a full 10 percentage points today. Again, the shift towards family setting is a good thing, or seemingly a good thing. But as with all changes, there can be unintended consequences. When I looked at data for the amount of placement moves a child experiences and placement disruptions in foster care, we see that moves for children has increased significantly. This suggests to me that our initial placement settings may not be meeting the needs of a growing number of children and youth. Fifth, among children who are investigated for maltreatment, are there racial differences in which children get placed in foster care? In North Carolina, we do see racial differences, but they may not be what the committee expects. I looked at data for children reported in the years prior to Rylan's law, the year that Rylan's law was implemented, and the years that followed. In every single year, white children who were investigated were more likely to be placed in foster care than Black or Hispanic children. These same patterns emerged when I restricted the data to victims of maltreatment. In
Your
other
2-minute
words,
warning. I'm sorry, you have 2 minutes.
thank you. In other words, we place a larger number of white child victims in foster care than Black or Hispanic victims. Are we overplacing white children or underplacing Black and Hispanic children? I cannot answer that question, but I do know that among children who've been identified as maltreatment, Black children are less likely to find themselves removed and placed in foster care. Finally, over time, and especially since Rylan's law, and given that fewer children are being investigated and substantiated and placed in foster care, is there data to suggest that child safety, health, and well-being in North Carolina have improved? According to the North Carolina Child Fatality Task Force, nearly 1,500 children died in 2022, the highest rate since 2009. Recent data from the North Carolina's medical examiner reports that the number of parent-caregiver homicides within the 0 to 11-month age group has nearly tripled from 2021 to 2022. They generously attribute this trend to, quote, the increased necessity for resources to support parents during this critical stage. But based on everything I have read, seen, and heard, I believe that efforts to shrink the child protection system are coming with real costs that are disproportionately borne by our youngest children in North Carolina. I will close by noting that I did not talk about the vast disparities in the age of children who are investigated for maltreatment. In North Carolina, as in every state, infants and young children are overrepresented, but no one would claim the system is having a disparate impact on babies because we realize newborns have unique vulnerabilities. Likewise, during one of the committee members, someone asserted that kids with disabilities are more impacted by the system. Perhaps, but what does that mean? Just as true for young children, those who have disabilities are more dependent on their caretakers for survival. And in a non-significant number of cases, disabilities that emerge are the indirect or direct result of prenatal substance exposure, which may continue to affect their parents after birth. Would the system be more equitable if we developed strategies to reduce our involvement with children with disabilities, infants and young children to match their overall population numbers? I don't think so. I hope this information will prove helpful to the committee. Thank you for your service in this role, and I look forward to your questions.
Thank you very much for your on-time remarks. We would now like to welcome Naomi Shaefer Riley, a senior fellow at the American Enterprise Institute. You now have the floor.
Thank you so much. And thank you to the members of the committee for allowing me to testify today. Bentley Smith, age 3, Amaria Noel, age 1, Cameron Noel, 3 months old, Camden Hairston, age 1, Safira Washington, age 4, Nia Ferguson, age 4, Carter Jimenez, age 3, Khalil Leak, age 2, Romy Tyler, age 1, Winter Robertson, age 4. These are just a few of the children who have died from abuse and neglect at the hands of their caretakers in recent years in the state of North Carolina. They are all African American. For many of them, significant risk factors for abuse existed even before they were beaten, strangled, or drowned. I know that this commission is already painfully aware of the tragedies that can occur when oversights happen in the child welfare system. I am honored to be able to speak to the North Carolina Advisory Committee to the U.S. Civil Rights Commission on Civil Rights today, because I believe we must be paying attention to the civil rights violations that were involved in these deaths of these children, the death of Rylan Ott, and dozens of others each year. As this commission may be aware, there are significant racial disparities in child welfare in this country and in the state of North Carolina. Would you please put up slide 1, if you could advance to the next slide? Thank you. Black children in this country are 3 times more likely to die from abuse or neglect than white children. Indeed, this number has been rising. Nationwide, 549 Black children died from maltreatment in 2022, 92 more children than in 2021. And given that North Carolina's overall number of child fatalities rose from 45 to 93 that year, a 106% increase, it is likely that some of this problem is happening here in your own backyard. Next slide, please. Black children are almost twice as likely as white ones to be abused or neglected in this country and in this state. Native children are almost 3 times as likely to be abused in North Carolina as white children. What is going on here? Where is the outrage over these tragedies? Why are Black and Native children disproportionately the victims of this violence? And why aren't our child welfare authorities doing more with the information that they have to combat this problem? Let us start with the causes. Next slide, please. There are a variety of factors associated with child abuse and neglect. We do know that poverty is correlated with child maltreatment and that Black families are disproportionately likely to experience poverty. But correlation is not the same as causation, and when we dig a little further into the numbers, we find that substance abuse and mental illness are actually underlying much of what is classified as neglect. These factors may cause both child maltreatment as well as poverty. Substance abuse and mental illness make it challenging both to hold down a job and to properly care for children. One commonly correlated factor in child abuse is domestic violence between partners. Black women are tragically almost 3 times as likely to experience death as a result of domestic violence or intimate partner violence as white women. And while Black women only make up 8% of the population, 22% of homicides that result from domestic violence happen to Black women. Another factor correlated with child maltreatment is family structure. Next slide, please. The incidence of physical abuse for a child living with a single parent and a non-relative male is 19.5 per 1,000, which is twice as high as children living with unmarried biological parents, and it is 10 times as high as for married biological parents. Single parenthood is a, quote, risk factor for child maltreatment in North Carolina, according to a report that's on the UNC School of Government's website. Children who are Black in single parent households are at a disproportionate rate to children who are white in North Carolina. 66% of Black children compared to 24% of white children live in single parent households. Family structure is an important factor correlated with the likelihood of child maltreatment, and it is one that disproportionately affects Black children. But none of these reasons, poverty, substance abuse, or family structure, explain why children whose caregivers were reported to CPS and other government authorities on multiple occasions were not rescued from neglect, abuse, and too often torture. And this, members of the advisory board, is where the pattern of civil rights violations, I think, begins to reveal itself. Time after time, we hear that child welfare agencies are racist, that they are needlessly tearing families of color apart. Indeed, testimony before this very commission has cemented the idea in people's minds that because Black children are more likely to be involved with child welfare agencies, that there is systemic bias in them. In fact, though, the truth is that Black children disproportionately need the help of our agencies, and telling agency workers that investigating or removing Black children is a sign of bias is encouraging them to leave Black children in dangerous situations. In 2021, a bipartisan Child Welfare Working Group, made up of researchers, former judges, agency heads, and nonprofit leaders, issued a paper called What Child Protection is For. In it, we explain that there is no scientific basis for claiming that expansions of prevention efforts can replace the need for child protection services to respond to crises. We still have ambulances to respond to car accidents, even though we have seatbelts and airbags. We still treat flu symptoms, even though we have an annual flu vaccine. Prevention and intervention are not competing philosophies. Both are needed to ensure child safety. But continuing to repeat this fiction that CPS is merely a tool of a racist power structure has put children in danger. The idea that any child welfare agency should concern itself with trying to reduce racial disparities in response to child maltreatment is itself misguided. Do we worry about racial disparities in the number of kids who have signed up for Head Start programs? Do we worry about racial disparities in families receiving food stamps? Of course not. It is the job of government agencies to help our most vulnerable populations and protect them from dangerous circumstances. Whether that is poor educational outcomes, malnutrition, or child abuse, everyone, regardless of their skin color, is worthy of our help. If anything, the concern with racial disparities in child welfare involvement is actually leading to decisions that are detrimental to the well-being of Black children. A report published by the American Enterprise Institute documents how many states are leaving children, especially Black children, in the foster care system for years at a time, long past what federal guidelines specify. For children who are not reunified with their families within 3 years, 38.7% of white children, compared with 27.3% of Black children, were still in foster care. In North Carolina, though, 45% of non-reunified Black children were still in foster care 3 years later, compared with only 31% of white children. According to a complaint filed last year with the Office of Civil Rights at the Department of Health and Human Services, Guilford County in North Carolina is, quote, removing African-American children from white foster and potential adoptive families based on reasons evidence indicates that were related to race. The complaint asserts that these removals are illegal under the Multi-Ethnic Placement Act, which prohibits discrimination in foster care and adoption on the basis of race and nationality. That law, along with the 1997 Adoption and Safe Families Act, sought to ensure that adoption was pursued as the best alternative for children when reunification was not viable. But a bias against transracial adoption means that a disproportionate number of Black children are left to languish in foster care year after year, and North Carolina is one of the worst offenders. Keeping kids in foster care longer than necessary and moving them before they can be adopted, as the HHS complaint alleges this state has done, can also produce greater trauma and a higher level of need for Black children, resulting in them going into congregate care placements at higher levels. As this commission continues to consider how to create more effective oversight of child welfare cases in the state, it is imperative to consider the importance of protecting the children most vulnerable to maltreatment. We owe it to children of all races to put aside our partisan ideologies and take the problem of child abuse and neglect seriously. Thank you, and I look forward to your questions.
Madam Chair, if you could please unmute.
Thank you. We will now hear from Miriam Mack, who is the Policy Director of Family Defense Practice at the Bronx Defenders. Ms. Mack, you now have the floor.
Thank you. And thank you for inviting me to contribute to this important examination of North Carolina's child welfare system, which I will refer to more accurately as the family policing system or family regulation system in Rylan's law. I want to begin not with statistics or national trends, though this data is important and I will get there, but rather with one family story that illustrates the profound harms caused by the family policing system and rushes to judgment often embedded in its interventions. In New York City in June 2020, baby C, a 3-month-old Black Latina infant, was brought to the hospital by his parents with seizures. Subsequent medical findings made by a child abuse doctor revealed a retinal hemorrhage and subdural hematoma. And the doctor concluded that these findings were consistent with a diagnosis of abusive head trauma. The hospital called the Administration for Children's Services, and ACS filed an abuse petition, and thereafter against baby C and baby C's sister, baby C was still breastfeeding at the time, and he and his sister were removed from their parents. The parents requested an emergency hearing challenging the removal, and after months of hearing testimony, of expert witness testimony, lay witness testimony, and receiving tens of exhibits, the family court determined that baby C's seizures and resulting medical findings were likely related to dehydration, inflammation, or infection possibly related to COVID-19. The court further found that the parents acted, quote, entirely appropriately, and quote, in response to baby C's condition. The tragedy of this case is profound. Instead of baby C and his sister being in the care of their parents and receiving the medical treatment they needed, they were separated. And while baby C and his sister thankfully were placed with family, that does not erase the deep, well-documented harm of separating children from their parents, even for short periods of time. And beyond the separation, baby C and his family lived under the strain of extreme unyielding government scrutiny and surveillance, and his parents lived with the knowledge that they were perceived fundamentally as a threat to their children, rather than a comfort and protector until proven otherwise. And I also want to lift up children that Ms. Riley has left out. Skylar Wilson, 4, Chance Witherton, 2 months, Braden Allen, 1-year-old, Nicandrel Deshawn French, 5 months old, Tamika Phillips, 11 years old, twin siblings Blake and London Devon, and the 5-year-old boy whose name we do not yet know, and the untold others, each of whom died while in the custody of family policing system agencies and/or adoptive parents. If we're going to honestly engage about the harm done to children, we must be honest about the harm to families and children that's inflicted by the system. My name is Miriam Mack, and I'm the policy director of the Family Defense Practice at the Bronx Defenders. Beyond working with parents charged with neglect, abuse, and the termination of parental rights over the last 7 years in both a direct representation and supervisory capacity, I have also worked in coalition with organizers and parents directly impacted by the family policing system across New York State to advocate for legislative change to increase the power of parents in the family policing system and to shrink the system. I begin with baby C's story because when I tell people that I'm a parent defender and a policy council committed to ending the family policing system, the assumption is that I don't care about child abuse or children being harmed more generally. This misconception is false, and I want to dispel that today. I start with these stories not to say that children are never harmed, but rather to illustrate the importance of us interrogating what we call maltreatment and abuse, and consequently build systems in response to, and what we do not call maltreatment and abuse. Because looking at data trends without also having an understanding of what's happening on the front lines, on the ground level, we lose important context. What I want to explore today is how we can simultaneously hold individual stories like Rylan's and baby C's and understand how they fit within larger patterns and frameworks in order to find true solutions to harm and abuse. So what do we know about the family policing system? The data makes inescapably clear the family policing system's vast scheme of surveillance, control, and prosecution impacts lives of thousands each year, and that underlying that system's vast reach are race and class disparities that panelists have spoken to today. Data show that more than 1/3 of children will experience a family policing system investigation by their 18th birthday. And when we distill down by race, more than half of Black children will experience a family policing system investigation. When we look into entries into the foster system, 6% of children will spend some time in the foster system. But that number jumps to 15% for Indigenous children and 11% for Black children. There are some that will suggest that these racial disparities reflect an appropriate response to Black, Latina, Indigenous, and poor parents' antisocial conduct that puts their children at imminent risk of harm. That there's something fundamentally flawed about these parents and their communities. This is a deeply racist and pathological view that conveniently ignores real structural factors like money, race, gender, and other accesses of privilege that shape who the government deems negligent and the government's responses. And narratives and justifications like this are not new. They've long been used to maintain social hierarchy, to control, punish, and dispossess Black, Indigenous, Latina, and poor communities. We also know that just as race is a strong predictor of who the family policing system targets, so too does class. Nationally, nearly 85% of families investigated by the family policing system have incomes below 200 of the federal poverty line. And indeed, the most reliable economic predictors of family policing are income loss, cumulative material hardship, and housing hardship. The data also show that the family policing system does not prevent abuse and trauma. Indeed, it is the source of abuse and trauma. Studies show that separating children from their families causes long-lasting disruption and harm, which panelists have spoken to before me. Even young children eventually reunited with their parents, like baby C, can experience traumatic stress and other lifelong consequences as a result of the separation. What's more, being in the foster system is associated with significant lasting negative effects, including increased behavioral problems, criminal involvement, and homelessness. And it's important not to underestimate the profound impacts that stems with living under persistent state scrutiny and the threat of family separation. And I've seen this with the clients that I have represented. During a family regulation intervention, there are few spaces that are off limits. Those families under the system's critical gaze are required to open their home to system workers whenever those workers appear, answer far-reaching inquiries into their mental health, medical, sexual, and romantic histories, disclose otherwise protected and deeply private health information, and have every interaction with their children scrutinized with no benefit of the doubt. Nor are family, friends, and community members or social service providers off limits. Rather, the system seeks information and surveillance by these systems and extended networks and deputizes parents, communities, and social service providers as de facto extensions of the family policing system. I note unequivocally that no child should ever experience abuse or assault. I firmly believe that we as community members have a duty to do all that we can to protect children and families from abuse. While it may be tempting to expand the family policing system where violence is inflicted on when violence is inflicted on children, or pursue changes like Rylan's law that seek to fortify, strengthen, and streamline the family policing system, we have to resist this temptation because it distracts us from real solutions that work to end abuse. And I want to meaningfully address abuse, we have to interrogate how racism and classism impact fatalities being attributed to maltreatment. While research has long established that child neglect is often synonymous with poverty, there's also a growing body of research that abuse determinations are infected with racism and classism. For example, in a 2002 study, researchers examined records in Philadelphia hospital database of children under 3 years old admitted between 1994 and 2000 for treatment of acute skull or long bone fracture. These types of injuries can be signs of abuse, but also of accidental trauma. In cases where the external reviewer found injuries that were indicative of accidental trauma, Black children were far more likely to have been reported to CPS or DSS for an investigation. Finally, while some will argue that child maltreatment fatalities are linked to efforts by family policing agencies to reduce the number of children entering the foster system, there are numerous jurisdictions that belie this assertion. Jurisdictions including New York City, Texas, and New Jersey have had significant reductions in children entering the foster system and have not seen an uptick in child maltreatment fatalities. On the other hand, Georgia, for example, both foster system entries and child maltreatment fatalities have increased. Instead of focusing on solutions that seek to expand, fortify, and streamline North Carolina's family policing system, the committee should recommend that North Carolina lead the way in building a different approach, an approach that invests directly in families and their communities. A key component of Rylan's law calls for improvement in areas such as providing services to families that prevent child removals. This is a valuable goal, and there's data to show the most effective way to get there. Data shows that when we address poverty, we address child neglect and abuse. Yet North Carolina consistently ranks poorly in spending on anti-poverty measures. In 2021, for example, North Carolina ranked 48th among states in Washington, D.C. for percent of TANF funds spent on basic assistance. For every 100 families in poverty in North Carolina, only 5 receive cash assistance. Yet North Carolina spends 13 times more money on the foster system and adoption than it does on programs designed to keep parents together. Shifting these policy choices could go a long way to addressing child abuse and maltreatment. Concretely, giving family monies is a child abuse and maltreatment prevention intervention. A 2016 study found that increases in minimum wage corresponded with a reduction in family policing involvement, particularly reports of neglect involving young children ages 0 to 5 and school-aged children ages 6 to 12.
Providing your 2-minute warning, please.
Thank you. Providing access to secure and stable housing is a child abuse and maltreatment prevention intervention. Nearly 30% of children could be reunited with their families if their parents had access to housing. Increasing access to public benefits is a child abuse maltreatment prevention intervention. Research shows that each additional $1,000 that states spend on public benefits program annually per person living in poverty is associated with a 7.7 reduction in child fatalities due to maltreatment. Another critical shift that's absent from Rylan's law, but sorely needed, is an investment in institutional holistic parent defense. I know that there are experts following me that can speak to how the state can better support parent defense, so I will keep my point short. Interdisciplinary holistic parent defense has been shown to be incredibly effective. Based on a study done in New York City, interdisciplinary holistic parent defense significantly reduced the length of stay in the foster system for children who enter, did not impact child safety, and did not impact the prevalence of foster system entry as compared to solo attorney representation. And going back to Baby C's case, interdisciplinary holistic defense was critical. It meant social work support for the family to ensure that their needs were being met and they were being connected with services necessary to secure the return of their children. And it also meant us being able to mount a defense that included medical expert testimony from medical professionals with expertise in the injuries sustained by the child and so much more. Finally, I implore this commission to recommend that North Carolina invest in open courts and transparency. As recent as February of this year, Durham Family Court promulgated a new local rule prohibiting parents, parties, and their attorneys from speaking to the media about their cases. Protecting children and supporting families and building strong communities is only able and possible when our institutions are democratic, transparent, accountable, and center communities. We cannot have accountability and meaningful change when institutions remain walled off from public access and critique. Families are safer when communities impacted can talk about their own experiences, enter courtrooms, and have the same access to information as institutional players have. Thank you.
Thank you very much for your time and your words. We will now at this time take a break. And we'll return at 1:05, and at that time we will begin our Q&A session with our panelists. Thank you. Hello again. I hope that everyone has returned. It is now 1:06, and at this time, I would like to reconvene the committee and our panelists for our Q&A. I will use the roll call and invite committee members to participate. Each committee member will have the opportunity to ask one question and a follow-up at a time. As time allows, I will go back down the row in case committee members have any additional follow-up or new questions to ask pertaining to the testimony. Committee members will also have the opportunity to send staff any follow-up questions in writing today after today's briefing, which will be compiled and shared with the panelists. I ask members to please keep your questions brief to allow time for sufficient response, and please focus on questions and not statements at this time. Members of the public will not be invited to ask questions of the panelists. I will now begin our question period, and we'll use my roll call. I can find it again. Okay. I'll begin my question, and this can be of any panelist that has spoken. As far as the Ryan's Law and the recommendations to have more social workers spend more time with the children and the families, can anyone speak on whether or not they see that there has been some improvement in the contact time that social workers are now spending with children? And have there been any positive effects that any of you see in any data? Thank you. And that is for any of the panelists. Thank you. Would anyone like to address my question?
Chair, I'm afraid I haven't come across any data that would allow me to speak to whether there's been any meaningful change in contact with social workers that would facilitate reunification efforts.
Okay. Would anyone else like to respond before I go to our next committee member? All right, thank you. I will now call on Daniel Bose.
Thank you, Chair. Let me thank the panelists all for taking the time to be here and sharing very clear information. Thank you very much for your work and taking time to share it with us today. My question is about the nature of North Carolina's decentralized sort of system and how that plays into it. As I understand it, North Carolina is one of about 10 states that historically hasn't had sort of centralized state leadership. And part of Rylan's law was moving more toward that central leadership. But my understanding is it's still pretty decentralized. And was just hoping the panelists could talk about how, that lends itself to any sort of civil rights discrepancies or really any issues that we've discussed today in regards, again, to the decentralization of decision making.
I can just briefly offer a comment on that. I spoke about the amount of time that kids spend in foster care, and we did at AEI, we had a report that looked at states across the country, and we found really almost no differences between states that were controlled more centrally and states that were county-run systems. So I haven't seen a lot of data that suggests that one system or the other is better, at least in terms of the amount of time kids are spending in foster care.
I guess I would just add that, your committee rightfully noted that in its project proposal, that North Carolina's lack of a statewide data system, is ongoing. And nationally, for example, we know that Black children not only enter the foster system at disproportionate rates, but they also remain in the system longer and experience a greater number of foster placements and are less likely to be reunified with their parents or adopted than white children. And so I do think, just one issue in terms of data is the failure to accurately capture and report out statewide data on issues like this hinders transparency and accountability.
I think the only other thing that I will add here is that what we do have good data on is that the provision of resources to families, direct material resources to families, does have an impact on the substantiated allegations of neglect and maltreatment of children entering the foster system, of length of stay in the foster system. So I think that's where a focus should be on how we can increase resources to families.
I just want to kind of both endorse something Professor Jolly said and question something that Ms. Mack said. So totally agree. It is kind of mind-boggling that North Carolina still doesn't really have a data system that's up and running. Certainly, it creates some challenges when it comes to reporting out, but I would argue that the larger challenges are much more operational for frontline staff who do not have complete information at their disposal and are having to both interact with multiple systems and pick up the phone to get data from across county lines. So that is an incredible challenge. We often hear that if we just provided more material supports, we wouldn't need our child protection system or fewer kids would enter foster care. I do believe that is true, but I think we need to talk about honestly what the scale of that is. And based on all of the research that I have seen, at most, we could expect potentially a 7 to 10% reduction in involvement with child protective services. So it's not to say that's nothing, but again, there's just no evidence that a majority of families are coming to contact with CPS because of poverty alone, as opposed to poverty as a backdrop to substance use, mental health, domestic violence, and other conditions that compromise parenting.
Thank you each very much for your responses. I will now go to Christopher Duggan for any questions you may have.
Yes, thank you all for the time you've taken today. I've got a couple questions, but I know I'm limited to one. So hopefully if we go around again, I'll get to ask the second one. But what did the panelists find as far as the situation that Ms. Mack talked about with baby C and having the determination that it was not caused by a physical abuse? And I think you said that afterwards, the family still was subjected to scrutiny and oversight. How does a family then get out of that situation where that it's deemed to be not as a result of abuse, but then are you seeing that the agency then puts them under a microscope going forward?
So yes, I can speak to that. I think what we see is that even when there's a determination that there is no imminent risk of harm to the child returning to the home, yes, there is continued scrutiny. The families are under the microscope, and it also doesn't change fundamental assumptions that were made about that family from the beginning. Fundamental assumptions that, as I noted in my testimony, are rooted in racism, are rooted in classism. And the longer and longer families are under the government's microscope, the more and more services that are piled on those families, the harder it is to disentangle their families from system scrutiny. And we see this time and time and time again. And I think we also see with the family policing system and its expansion into social supports and community members, it makes families reticent to access the very supports and social services that are needed to create the conditions for safe communities and safe families. I think that it's not unique or a mystery what is needed to create the conditions for safe families and safe communities and supported communities. We see that access to well-paying jobs that pay a living wage, access to housing that's stable and secure, access to schools that are well-resourced, all of these things contribute to families and communities being strong and stable. And none of that is really a part of the family policing system intervention when we see them come into families' lives and continue to regulate even after a determination is made that the injuries that the child suffered were not due to abuse or neglect.
Thank you.
You may follow up with your second question.
Yeah, the second question was for baby Tim, where the parents' visitation was reduced. What can the family do after that? That the court makes a decision. Obviously, it's a long and lengthy process, I'm sure. Being in litigation myself, I see that all the time. But a family that's poor and doesn't have the resources, what are they left to do in that situation?
Yeah, great question. And I appreciate you thinking about that question too. I mean, there's always the opportunity that a attorney on behalf of a parent can file a motion and seek to expand visitation, right? I think the problem though is that courts are very deferential to DSS and GALs, right? And so if you have DSS and the GAL aligned in that visitation needs to be further restricted, that case is headed towards termination of parental rights. And it's a real uphill battle to convince a judge otherwise.
Thank you.
Thank you very much. I will now call on Jonathan Duzay.
Thank you, Madam Chairwoman. I got a question I'd like to ask all four members if I'm allowed to do that, any or all of them, and that is, we're going to end up with a report that includes some recommendations. You could pick one thing, one recommendation of how to improve our child welfare system here in North Carolina. What would it be? Sorry, I didn't mean to be hiding. I just
I'm happy to start. And interestingly enough, I think I may be able to offer a recommendation that all the other panelists would endorse, which is that I think greater transparency is really important. Miriam, that was something that you brought up, that families should be able to speak. And I also think that the division in the counties should be responsible for releasing more information to communities and to the public about the decisions that are being made. And so if we're concerned broadly about civil rights, we may differ a little bit when it comes to whether right now we're erring too far on the side of parents versus children and whether child safety is compromised. But I think that we could all agree, and it would be tremendous for there to be recommendations for greater public accountability through transparency.
I would echo those recommendations. Certainly, departments across the country often find themselves in a position where the family is making claims about a particular case, and agency representatives are prevented from speaking about the case. And so only one side of it is really revealed. And I think the public needs to know everything that's going on, or as much as can be known, given laws about confidentiality. The second thing I would add to that is something I spoke about in my testimony. I think that North Carolina needs to be paying attention to the federal guidelines of the Adoption Safe Families Act and the Multi-Ethnic Placement Act to ensure that kids are not left in foster care indefinitely. There was a lot of bipartisan agreement about this in the 1990s, and Congress passed those laws with full support of both parties, including the Congressional Black Caucus, despite the fact that those laws are now called racist on a regular basis. And I think that the reason that those laws were passed was that we saw kids, and Black children in particular, being left in foster care for very long periods of time because what you saw was an opposition to any kind of cross-racial adoption. And I think North Carolina, as evidenced by the civil rights complaint that was launched against HHS, has been unfortunately moving back in that direction. And I think some oversight over this question, ensuring that the agencies understand what the federal guidelines are and understand what caseworkers should be doing in these cases where children have been in care for long periods of time, moving them to permanency as quickly as we can is very important.
I think the one recommendation that I would lift up here as important for the committee is really following the leadership of people who have been directly impacted by the family policing system, who have survived the family policing system, both as children, also as parents and caretakers, is really to invest in families, invest directly in the form of cash assistance to families. I know that some of my colleagues on this panel indicated that we would only see sort of marginal differences in terms of abuse and maltreatment if we were to really sort of bump up some of the resources to families. But one study that I referenced in my testimony, I think, is an important one to think about, where when we provide safe and stable housing, 30% of children could reunify with their children or with their parents. So really, I think my recommendation would be to invest directly in families. North Carolina, a lot of the TANF funds that could go directly to families is actually used to support social work staff of North Carolina's DSS. So really transitioning that money into communities and families.
I would echo a lot of what Ms. Mack said and simply state that nearly every major child welfare thinker, researcher, even major institution agrees that there is disproportionality in the family regulation system and that changing economic conditions for poor families gets us closer to safety. Ample evidence demonstrates that wide-scale government policies that reduce childhood poverty by increasing family income and meeting families' material needs for housing, food, healthcare would dramatically lessen the harms to children that this system claims and fails to address. Children flourish when their parents have what they need. And while child safety is often pitted against the rights of parents, enhancing the conditions under which parents raise their children is child protection work. And reforms that build power in fundamental ways that might be feasible and effective enough to chart a path forward actually supports families.
Could I have a follow-up with Professor Jolly? To be honest, I don't think this committee or even the U.S. Commission on Civil Rights is in a position to do much about poverty. But we can make specific suggestions that might conceivably be enacted regarding the existing social welfare system. And you were the clearest, I thought, of all the panelists in what you were recommending. I just want to be sure I got it right, and that is change the default rules regarding family visitation. Is that what you would say was a very important reform?
Yes, I mean, I would say, early, consistent, frequent family time in the least restrictive setting necessary is crucial for maintaining parent-child relationships, mitigating the trauma of family separation, allowing family reunification to be achieved and sustained. Kids are removed from their parents and it takes weeks before they have their first visit, right? There should be contact within 24 hours. Upon a court determination that that a child is removed from their parents, the court should forthwith order, family time plan that provides the maximum parent-child contact possible, and maximum should be presumed to mean daily, and shall be determined by the individual needs of the family, not by the resources of the state agency, nor the availability of the foster parent to transport the child.
Thank you. That's all I have.
Thank you very much, Donna Oldham.
The one thing that I have heard consistently gives me pause is the lack of a database or the lack of technology for information sharing. What solutions can you recommend that the state could adopt to make information sharing easier? And that's to all the panelists.
I'm happy to jump in first, although I think my answer will be partial and it might be something that the panelists who are on I think the government panel might be in a better position to answer. But my understanding is that despite spending upwards of $100 million in a new CWIS system, which stands for Child Welfare Information System, that still has not been implemented fully. I will say that North Carolina is not alone in struggling to transition from legacy systems to new systems, but I certainly think that there should be a real heightened urgency given the implications that it has, again, for serving both children and families across counties. The other thing that I will bring up is that I do think that North Carolina continues to use risk and safety tools that are significantly out of date. North Carolina's DSS just went through a whole process of updating their structured decision-making risk tool with what was previously the National Council on Crime and Delinquency and is now Evident Change. But even with those updates, it is incredibly rudimentary, which means workers are manually gathering and entering a handful of data elements to determine safety and risk, as opposed to, as you mentioned, using information that would provide a more holistic understanding of the protective factors that are available to the family, as well as the safety concerns. So I also think that North Carolina should be looking more closely at not what tools were appropriate back in the 90s or early 2000s when they were first adopted, but what some of technology and best practices around risk and safety assessment look like today.
Thank you.
Oh, I'm sorry. So just quickly to respond, I think that it would not be my recommendation actually to center a recommendation on investing in centralizing data systems. I think that number one, we have to sort of problematize the data that is being gathered. And again, no data is neutral. And a lot of the data that is being gathered and that would be centralized and would be used to further surveil families by having more agencies speaking directly to each other in tandem is data that is deeply tainted by racism and classism. And so I think before we go on a journey of trying to gather more data on families and having more systems speak to each other about these families and increasing the reach of the family policing system, we really have to question and problematize the assumptions that underlie the data that we have, some of the biases that are deeply embedded in our society, and shape the decisions and determinations that are made by people that then produce this data. And I think that instead of thinking about how can we invest in centralizing, streamlining, and strengthening the system, there are concrete steps that can be taken in this moment to actually limit the scope of the North Carolina's DSS and reinvest that in communities. And just one example here is actually to decline using TANF funds for DSS and instead transition those funds to families. I know that there's other speakers that want to speak to this. I have more. We can end mandated reporting. It's a system that has been shown to not be effective, but I'll pause there.
Would anyone else like to respond to that question?
I just wanted to respond very briefly. I think that the committee is obviously very interested in a lot of these outcomes, and I think that it would be a mistake to bury our heads in the sand and say that we're not interested in particular kinds of data because the data themselves are biased. I think the committee members have a lot of very good questions, and we're interested at every stage of the child welfare system in who is being involved in it and why. And I think it's very important for the sake of both the people making policy, but also the public to understand what's going on here. And I think to sort of push ourselves away from data and suggest that the data itself are the problem, I think is going to create more problems in the long term.
I would just add, I don't think I have any expertise on the database issue. I would leave that to folks that are testifying in upcoming briefings. I think I would just say that each county operates differently, as we know, and counties still have unyielding power without oversight from the state, right? And I think that is an issue with transparency and accountability.
Thank you all.
All right, did you have a follow-up question for anyone?
No.
Thank you. All right, I will now call on Catherine Reed.
Hi, thanks everybody for your testimony. I think that one of the panelists mentioned the opportunity to learn from other states that are doing this well. I don't know if anybody wants to comment on other states that we could examine in our research that are addressing any of the issues that you have raised today through, our recommendations.
I know I was the one that mentioned examples from other states in my testimony regarding visitation specifically, and I'm happy to just, share out a few of those. For example, Georgia presumes that visitation shall be unsupervised. Alabama provides that visitation should be organized around events like shopping, picnics, recreational outings, and visiting arrangements should encourage parents to be engaging in the parenting role through activities like doing homework, and providing whatever care is needed for the child. Florida provides that visitation shall occur in a home-like setting and unless unavoidable, not in an office. Washington explicitly states that visitation cannot be used as a sanction for a parent's failure to comply with court orders or services. And finally, I'll just share Iowa considers whether a mother is breastfeeding her child when creating a visitation plan.
I just wanted to add quickly, when we did our study looking at how long kids were left in foster care, we found that Utah performed very well. And one of the reasons that they did, we found on further investigation, was that their family court system is very efficient. Their hearings, 30-day hearings, 6-month hearings, 1-year hearings, those are really held more than 90% of the time on time. And I can tell you, having visited a number of family court systems, that is quite rare. I suspect Ms. Jolly would agree with me on that. But part of the issue here is that there's a whole child welfare system here that is not just the agency, it's also the court system. And so getting judges, getting lawyers, to act in a timely manner, understanding that a child's timeline is different from an adult's timeline, is very important in making the best decisions for these families.
Well, I think also what I would recommend, I think the New York Advisory Committee to the U.S. Civil Rights Commission investigating New York's family policing system is a good place to start. In terms of their analysis of the strengths and weaknesses of New York's system. I think, when thinking about timelines, I think what I would say there is that, speed can't be the only part of the analysis. A meaningful ability to litigate these hearings, having meaningful access to representation for both children and parents, having resources available to be able to consult with expert witnesses, with having services available to support the family and invest in the family is a part of the analysis. And so I think one of the things worth looking into is looking at the states that or jurisdictions that have embraced interdisciplinary holistic parent defense, which again, as I raised in my testimony, has proven to be effective in lengthening the stay of children in the foster system and not causing increases or risks to child safety. And, I think that I just want to sort of complicate here the notion that children's rights or timelines for children is oppositional to that for timelines for parents and parents' rights. Really, I think that a lot of what we have talked about, a lot of the studies, but also more importantly, the information and lived testimony from folks who have survived the family policing system is that those are not in tension. And that often when we invest in families and invest in communities, we are investing in children as well.
Catherine, did you have a follow-up question?
Thank you. It's not a follow-up to that specifically, but and it may be too existential, but I wonder, based on the testimony and just sort of hearing and read, what we've learned so far about this, I wonder if the panelists could talk to whether trust can be rebuilt. It seems there's a huge gap here between, even the language that people are using, right? Child welfare versus family policing. Are we ever going to be able to get to a point where there is trust between these families who the system was built to look out for the children. It feels very, even in the best case scenarios, and you know, is there a point at which, and what will it take to get the trust between the system and families? Is that possible in the panelists' view?
I think that's a great question, and that's one that I obviously would defer to the communities that are most impacted by and targeted by the system. I think my response to that is that rebuilding trust depends on a level of honesty about what the system is, why it was designed, and how it functions. And it really means a sort of meaningful engagement with that. I think it is very hard to build trust when you are working from different realities and working from different understandings of how the system actually operates. I mean, even sort of complicating the fundamental notion that the family policing system is designed to protect children and to support families. And when we have myriad families that will speak directly to the fact that the family policing system has not helped them and has not helped their children. And in fact, they have seen generations of the family policing system intervention that has only destabilized their family. And this is not to say, I want to acknowledge here, there of course will be people who testify before you and who this committee interviews or receives feedback from, who will certainly say that they developed a good relationship, a supportive relationship with their worker, or that there was a system that did help them, or they did find relief. I'm not trying to suggest that experience doesn't exist. But what I am saying is that taking that experience and also understanding the legacy of the family policing system and its relationship and connections to other policies that have been used to systematically oppress and disenfranchise Black and Brown and Indigenous communities. I think there has to be an honest conversation about that, a reckoning with that before there can be any sort of inkling of trust or question of how do we sort of repair harm and move forward together.
What I would add, and I kind of again want to echo what Ms. Mack said. I think there's incredible role confusion here. I am very sympathetic to our child protection or child welfare agencies because I think we ask them to be all things to all families. I strongly believe that the agency that has the state power to bring you to court and potentially remove your child is probably not the agency that should be providing all of these kind of anti-poverty supports that keep coming up. But we want to protection as being a holistic well-being system, or we talk very abstractly about if we just put these resources in the community. So I would totally get on board with a much kind of narrower description of what that agency does. I think that would help build trust. But to be clear, no family is ever going to want to be involved in the child protection system. No family should ever be told that that is a good thing, and we should try to reduce the footprint. But that doesn't mean we shouldn't also invest strongly in a child protection system that does its job well. And I think that all these conversations are very distracting and leading to a kind of a retrenchment of that system and a feeling that if we somehow place children in foster care, that is a failure of child protection, as opposed to a failure of all those other systems.
Thank you for your comments. I'm sorry, Ms. Riley, did you want to comment? Okay, I just want to make sure I'm not leaving anyone out. I will now call on Mercedes Restuccia.
Hi, thank you, speakers, for your testimony and candid conversation. I think my question, it probably shows a little bit how just like ignorant I am on the topic, but we keep on referring to this default rule And I'm curious if you could explain that a little bit more to us. If that is that like a state regulation, federal regulation, and any comments that you want to make associated with that? I think it was Professor Malley that might have mentioned it first with the visitation default rule.
So I can certainly speak to that. Yeah. So in terms of the visitation default norm, I think it's to answer your question, it's a combination of law and practice norms. So the law provides that appropriate visitation should occur as in the best interest of the child, consistent with the child's health and safety. And so how that has been interpreted in practice is what I was referring to, right? Which is it's been interpreted as 1 hour once a week, supervised. And I think that's true for most of these practices, right? Is that it's a combination of law and how it is interpreted county to county, and resources are obviously a big relevant factor in these default norms.
Right. And I guess I have a follow-up, but I want to make sure nobody else had a comment on that. And I guess when we're saying kind of default practices, are counties that you know of adopting policies that are really like putting this in writing, or is it just like a cultural practice?
So that's a great question. I appreciate you asking, because I should clarify that in terms of policy, like North Carolina's policy, for example, on visitation is pretty decent, right? I mean, the policy as written provides for a much more robust contacts between parents and their children. The problem is it's not followed, right? That policy is not at all followed by any stretch of the imagination.
Thank you. That clarifies it. Writing reports, it's nice to sometimes be able to use citations, and thank you.
All right, I call on Gregory Wallace.
Thank you. I thank all the panelists for taking time to participate in this very informative session. I have a problem that I want to see if you can help me with. I'm trying to disentangle our mission as a state advisory committee to the United States Civil Rights Commission, which focuses on civil rights policy, civil rights laws, particularly discrimination on the basis of race and other protective factors, with concerns on the other hand in this topic about, for example, broad concerns about social problems like poverty and drug abuse. I think Jonathan Guzet mentioned a minute ago that the Civil Rights Commission is not really addressing broader issues of the existence of poverty and those kind of things. And also disentangling that with just a sort of best policies for our child welfare system. I don't see our mission here as focusing on just reassessing the child welfare system in North Carolina and making recommendations. I'm trying to connect this up with civil rights policy. Now, I know Ms. Mack has talked about deeply embedded racial biases and classist biases within the system, but I do want to read the report you cited from the New York State Advisory Committee on New York system there. Maybe will help. But I was wondering, particularly with the other three panelists, can you help me connect up the concerns that have been expressed today with a particular emphasis or focus on civil rights as traditionally understood, and as the U.S. Commission on Civil Rights concerns itself with. I don't know if that question's clear or not, but I'd like to hear if anybody can help me connect that up.
I guess I'll take a stab at it. Obviously, the basis of civil rights is equal protection. And I think where the folks on this panel probably disagree is what constitutes protection for children in the system. I think that we need to be very concerned about the children who are abused and neglected. I think that we're underestimating the seriousness and the extent of what neglect means. And I'll just take a brief detour, if you don't mind. Both Professor Putnam-Hornstein and I have both mentioned the co-occurrence of mental illness, substance use, and domestic violence with poverty as often being a part of neglect. And I just want the committee members to sort of take a minute, especially I'm sure many of you are parents yourselves, if not grandparents, to think about what it means to care for a small child in your home when you are suffering from severe mental illness, addiction, or domestic violence. And to dismiss the concerns about neglect as something that could be solved by a housing voucher or TANF funds, I think is really underestimating the extent of the problem that we're seeing with some of these kids and the level of protection that they need. So when I think about what the role of this committee and the U.S. Civil Rights Commission is more broadly, it has to do with thinking about these children who are quite vulnerable. And as I suggested in my testimony, it seems that for a variety of reasons that are not endemic to the child welfare system, Black children in particular in this country are at higher risk for maltreatment. And the question is what the child welfare system needs to do in order to provide equal protection to those children. In some cases, that means that it needs to provide their parents rehabilitation services. In some cases, it means that their parents may need some kind of material provisions. But in some cases, it also may mean that their child needs to be separated from them temporarily and every once in a while permanently. And so I think asking ourselves what we mean by equal protection is probably the basis for answering the committee's role in understanding the problems with child welfare.
I think I can also weigh in here, although I do recognize that the question was posed to the other three committee members. But I think part of the critical function of this committee, right, is also honoring that it's a civil rights violation to violate the fundamental right to familial integrity, a right that is enshrined in our national constitution. It's a long-held right, and that the Supreme Court has long made clear that intervention into families, including interventions by DSS and the child welfare system, actually is required to meet constitutional muster of the least restrictive means to meet a compelling state interest. And I think when we're sort of, you referenced talking about broader sort of policy issues like poverty or like things that communities like Black communities, poor communities, low-income communities are facing, and how does that connect to family policing and investigation of civil rights violations in the family policing system? I think it very much is a question of civil rights violations as to what is driving families into the system. And if driving families into the system is divesting in communities and under-resourcing communities and racism, I think that absolutely is important and weighs upon the civil rights inquiry. I think it absolutely weighs upon the civil rights inquiry if there are any interventions that can be made, recommendations that can be made to North Carolina in order to ensure that if there is state intervention, that it is in line with our constitutional law, the least restrictive means to meet a compelling government interest. And I think in order for us to think about these recommendations, we also, the family policing system doesn't exist in a vacuum. Therefore, our recommendations shouldn't be made in a vacuum. We have to consider how other policy choices, how other social policy choices impact how the family policing system operates. I agree with Ms. Putnam-Hornstein that the system is far too big and is asked to do far too much. And so I think a worthy recommendation of this committee could be, how can we invest in other social systems that have been proven to support families, that have been proven to support child well-being, in order to ensure that we are not unduly expanding the footprint of the family policing system and further exacerbating longstanding civil rights violations.
I guess I would just add, I mean, I think I'm struggling a bit with your question, because I think this is the most important civil rights issue of our time. You know, we are deeming certain families as unworthy of being together and other families as worthy of being together, right? And legislatures, the judiciary, and scholars are beginning to voice what people with lived experience have decried for decades, which is that separating children from their parents has devastating long-term consequences, right? And child protection law, federal child protection law, provides funding to states based on claims that remaining in the home would be contrary to the welfare of the child. And this very standard invites bias and overreach. And it allows families to be separated due to poverty and subjective determinations of acceptable parenting. And, you know, I know that some of my co-panelists have talked about that it's never just poverty, it's poverty and mental health issues, or it's poverty and domestic violence issues. And I just want to address that for a second and say that that is still part of what I'm talking about, right? I mean, domestic violence doesn't exist in a vacuum, right? I mean, part of why domestic violence issues spin out of control is that people don't have anywhere to go, right? I mean, somebody who has resources, who is being abused, can simply, you know, go to another home. They have a different housing option. When you lack money and resources, you don't necessarily have that option, right? I mean, take mental illness, right? I mean, folks who have money receive different types of mental health care than folks who don't, right? And so I would just say that it's related. And I guess, you know, our society continues to perpetuate this long debunked myth that the foster system ensures that children will live better lives. And I guess I would just end with, you know, Joseph Doyle is this MIT economist who has compared outcomes of children who face the risk of removal but remained in their parents' care to children who were actually removed from their parents' care and placed in the foster system. And the group that remained at home had better long-term well-being outcomes, whereas the children placed in the foster system experienced higher likelihood of criminal legal involvement, substance abuse, teen birth, dropping out of school, and becoming homeless. That's a civil rights issue.
Just very briefly, I want to only address the research that Professor Jolly mentions, because that gets cited left and right. And all of the new econometric research that comes out really debunks that earlier finding. I would encourage you to look at some of Jason Barron's research, which is actually with Joe Doyle and others. So just wanted that on the record.
All right, thank you everyone for your time. We are now going to move on into the public comment section. I want to thank all of our panelists for presenting today and for the committee's engagement. We will now transition to public comment. If we run out of time and members of the public are interested in sharing comments with the committee, please remember we will continue to accept written testimony until September 23rd. 2024. Before we begin public comment, I'd like to remind committee members that this is an opportunity for us to hear from the public. This is not a space to engage in discussion or substantive questions. If a committee member needs to make a clarifying question of a public commenter, please raise your hand, and if time allows, I will use the chair's discretion to determine if the question is appropriate. I would like to remind members of the public that the United States Civil Rights Commission is not an enforcement agency, and the committee's primary task is to send recommendations to the commission. The committee section, we are required to obtain the legal names of anyone providing public comment. And to provide a comment, please raise your hand in Zoom, and you'll be called on in the order that your hand was raised. We would like to remind the public commenters that they have 3 minutes and will be given a heads up when their time is almost up. Please do not defame or degrade any person or entity. If needed, we may intervene to redirect the comment to the topic at hand or to maintain a respectful environment. And after warning, the chair and staff have the right to mute anyone or adjourn the meeting if needed. Written comments can be submitted to lschiller@usccr.gov by September 23rd, 2024. I now ask the staff if anyone has raised their hand, and the staff will check and give them the ability to unmute.
Thank you, Chair. At this time, I'd like to ask Todd Kiago to speak. Please wait until the timer is visible on the screen and you can begin your comments when the timer begins.
Good day. Can you hear?
Yes, we can hear you.
Okay, thank you. First of all, thank you very much to everyone that has contributed to this paneling. I know the research and reading records and etc. takes time and so forth. So again, I want to say thank you to you. Being that this is a public comment, I'm going to kind of address the degrees of what Ms. Reed asked about trust. And so as a my family as a victim from the DSS services or CPS, however we're calling it, and especially within the state of North Carolina, we completely comprehend something which Ms. Mack said, the constitutional muster that's needed by these fiduciaries to engage in these matters. Now, Senator Nancy Shaefer put out that the family policing system would be used against families in a malicious manner in order to separate families, when family is the foundation of this entire thing. Now, let alone being engaged with agents, again, fiduciaries, who seek to find out if, for example, they wanted to know if we were American Indian and what tribe we are. Currently, within the culture, people are going back to their Aboriginal roots. We have a fiduciary relationship with the United States, and it is bewildering that the fiduciaries within the court system, the fiduciaries within the public services departments engage in such a manner that they're tearing families apart. Now, let's not get it twisted that there are moments where it's needed. There are people out there, but the Social Security Act is made to help families. The system itself, as was said earlier, is made to assist the family. The issue is the fiduciaries. That's our problem. And many a times, families have called these agents out for their maliciousness. Just recently, Justine wrote about the Cherokee DSS DA who engaged in obstruction of justice. Over 10 counts. That family can't get that time back, no matter how many millions of dollars they receive. I thank you for your time. Thank you.
Thank you for your comment. At this time, I'd like to ask Amalia Petian Wilson to speak.
Hello.
Hello, yes, we can hear you. You can start.
In my case, The CPS investigator came into my life on the 5th of December. She informed me she was reviewing my case. She has lied and said that my daughter had a broken arm and my daughter had a hairline fracture on her finger when she got disciplined by her father. The first time that I actually met this lady was on January the 2nd. The second time that I met this lady was on January the 16th when she had me arrested. I was arrested for 2 days. My children were left home alone. She never checked on my children to see if they needed anything, if they were all right. When I got out of jail, I contacted her supervisor and told her that I didn't think a proper investigation was done. They didn't speak to my adult children to see what kind of parent I was. They didn't talk to family or friends or co-workers or any professionals that knew me. I'm sorry. And like I said, she lied and said that my daughter's arms were broken. She stated on the stand that my children felt safe with me, but yet they still took my children away from me. I didn't see my children for the first 4 months that they had my children. I think the problem is the fact that we have some dishonest workers that are in the, in the DSS department, and that's how, I'm sorry. But that's how, my case, I guess, got worse, is the fact that this lady has lied about a whole lot of things. My names have been forged on documents. I have proof of everything. All the lies that she told and all the forged documents, I have all of those. That's all I have.
Thanks very much for your comment. At this time, I'd like to ask Richard Wexler to speak. Please wait until the timer begins.
Hello, my name is Richard Wexler. I'm Executive Director of the National Coalition for Child Protection Reform. Thank you for the opportunity to speak this afternoon, and even more, thank you for addressing this vital topic. I'll start with a question. Where else but in what they like to call child welfare do people point to their worst failures and use those failures to justify doing more of the same? Those tragedies that Naomi Shaefer Riley mentioned, they didn't happen under a new approach, one built around safe, proven alternatives to child removal as we advocate. Every one of them happened under the system we have now, and a system whose coercive aspects they want to make even bigger. What has the current system gotten us? A giant child welfare surveillance state. Ms. Mack gave you the data on how astoundingly big it's become. Putnam-Hornstein has proposed making it bigger. Millions of children over the decades needlessly consigned to the chaos of foster care.
Mr. Wexler, if I may ask that you please do not defame or degrade any organization or person.
Sure.
Thank you.
Sure. Respectfully, I am quoting them, but I will stop doing so. I do not mean in any way to defame or degrade. I do mean to challenge and contest. Staggering numbers abused in foster care itself. We were reminded of that just this week in the case of the Fayetteville foster mother who adopted 5 of her foster children and now stands accused of torturing all 5 and killing 2 of them. And all the time, money, and effort wasted on false reports, trivial cases, and poverty cases is stolen from finding the few children in real danger. The system that we have now has made all children less safe. I will go into some specifics about some of the things you have heard in my written testimony. There's certainly not time in 3 minutes. I do want to close, though, with something where I agree with Putnam-Hornstein. I want to close by addressing the last comment at your previous meeting from Marcella Middleton, a former foster youth, asking that you not forget those like she who really do need to be taken from their parents. She's right. Such young people must never be forgotten. But who's really forgotten them? Or worse, is exploiting them? In the world we envisage, when workers are not burdened by endless false reports and poverty cases, there is a greater chance that young people like Ms. Middleton will be rescued. We've tried it the other way for more than 50 years. You can help set North Carolina and maybe the nation on a better path. Thank you very much.
Thank you, sir, for your comments. I would like to ask if any of the panelists would like to respond to Mr. Wexler's comments.
I would just quickly like to say that I think Miss Putnam-Hornstein said she wanted to shrink the child welfare system and thought that too many children were coming into it because the child welfare system's mandate is too broad. So I think Mr. Wexler probably mischaracterized Miss Putnam-Hornstein's testimony there.
Thank you, Ms. Wiley. Would anyone else like to comment? Any panelists? All right, thank you, and I will turn it back over to the staff.
Thank you, Chair. The next person whose hand is raised is Yolanda Rushing. And before we start the timer with her, I'd like to ask Yolanda, are you aware that your hand is raised twice on the list? It looks like you're there twice. Yolanda, can you hear us? Yolanda, if you can unmute, please go ahead and just let us know if you're aware that you're on the list twice, please. Hello, Yolanda. I think we're having trouble hearing you for some reason, so I will move ahead with the list, but come back to you. I apologize for that.
No,
Can they hear us? Who's Yolanda?
Okay, we can hear someone now. Who's speaking?
Jerry Anderson. Jerry Anderson.
Jerry Anderson. Okay, and just for the record, are you there currently with Yolanda, and is she planning to speak as well?
I'm not with Yolanda, but I'm sure she wants to speak.
Okay, so we will need to have you speak first, and then later on in the call, I'll get back to Yolanda. But Mr. Jerry Anderson, please begin your remarks when the timer starts.
Yes, ma'am.
The timer has started. You're free to go ahead.
Yes, ma'am. I'm Jerry Edwin Anderson, live in Cabarrus County, and on 4/9/2016, I had an experience with DSS where I went to them for resources for my mental child who was 25. She was a federal helpless child. I was a veteran and she was my child. And my grandchild was her daughter. And when I went to get help, they got very interested in my granddaughter who was biracial. She was black, and they got very interested in her. They neglected my daughter, and on 4/9/16, they come to my house and took with the police, took the child out of my house where she lived, where she'd been going to school this was in April. She'd been going to school all semester, and nothing was wrong. Child was great. We loved her. It was all about my daughter's mental. We were poor, and it was my mental daughter that I had concern was trying to find resources. But they come that day and took my granddaughter from my house, and I asked them why. And they said, "You didn't get a telephone call?" I got it recorded. And I said, "No, I didn't." And they never told me why they took my child. I go to the board every month and I say, "Why y'all take my child?" Nobody will tell me. The two agencies that were here, DSS and the Kannapolis Police Department, I asked them, "Why y'all took my child?" They have no reason. And I've asked this and asked this. They took her illegally. I didn't have proper, no reunification. They took her out of my life. I've never seen her again since that day. We raised her 7 years, never seen that child again. And my daughter was neglected, and she loved that child so much, she died. And today was the day that my child died, like 3 years ago. Her mama died. I'm not even sure she knows her mama's died. And this child's 15 today. And I love that child to death. And I need a reason why she was taken from my house. My house. My daughter was in the hospital at the time because they abused her so bad. And she was taken care of. Thank you very much.
Thank you for your comment. The next speaker will be Martha Grice.
Hello?
Hi, Martha. We can hear you. You can go
Okay.
ahead and get started.
Hi, I'm Martha Grice Haney. I'm a school teacher in Union County, North Carolina, and I am actually wondering, even with the case of the man that just spoke previously, like, who is it that someone can contact for DSS when DSS becomes the abuser? When DSS neglects the kids, when DSS takes kids that they're not supposed to take. So who is the agency that actually oversees DSS and guarantees that what they are doing and the way that they are conducting their enforcement is actually in the best interest of these children? And not only that, who do you contact when DSS is the one actually abusing the children? I could go into my story and tell you, not only am I a school teacher and been a school teacher for 25 years, I was also a certified foster caregiver. And I had 3 of my grandchildren that were taken from me. And when I tried to go and find out why they were taken from me, I had absolutely no one that would come and help me. I had no one that I could report this to, no one that would come up and help me with the abuse that DSS has done to my children, to my grandchildren. And I guess my question is, who is it that someone contacts when DSS is the abuser? When DSS is abusing the kids medically and having the kids go to different medical appointments so that the foster parent can get extra money and have a 1-year-old diagnosed with different types of ailments, like so that they could get more money in the foster care system. I guess I'm rambling on, and I don't mean to be. I just there's just so much that has happened to me that I guess that's what have the tendency of doing. But my main question is, who is it that you can contact when DSS becomes the abuser?
Thank you, Ms. Grice, for your comments. I would just like to quickly respond. The committee is currently studying this topic, so I am not sure if they would have a direct answer for you, but your question is one that they can consider as they continue working on this project. So thank you again for your comment. At this time, the next speaker is Lolita Allen.
Hello, thank you for allowing me this opportunity to speak. Can you hear me?
Yes, we can hear you. Go ahead.
I wanted to comment on about the ability to trust DCF. My name is Lolita Allen, and I am a registered nurse. and I had a disabled grandchild who's severely disabled. And I want to equate my situation to slavery. And the reason I do that is because this system treats us like slaves. I'm referring to a particular time when we were not as slaves, our ancestors were not allowed to read. And one slave said to another slave, "You don't want to learn to read." And the reason you don't want to learn to read is because your eyes are open, you know what the oppressor is doing or what the oppressor is planning to do, yet you don't have the ability to stop it. And that's worse than not being able to read. And the reason I equate that to my situation is because as a registered nurse, my job was to process private duty nursing claims, which allows disabled children to get the services that they need in the home. And I was dubbed Queen of Private Duty Nursing at my job of 15 years, where I processed those claims. However, when my child needed those services and she was denied, I began to use my professional expertise to advocate for her. And I knew exactly what they were doing, how they were doing it, but yet I did not have the ability to stop them. My child was taken away from me, placed in a nursing home at the height of COVID. With her severe disabilities and her complex medical conditions, my child was at grave risk for literally death because she was blind, could not talk, could not walk, could not speak, and do anything for herself. But yet Child Protective Services used strategies and lies and tactics to take my child from me. And I was told by the court-appointed guardian for my child, my grandchild, that she screamed and yelled at me and said, "I need to do whatever they say do, even though they're wrong, because I don't have the power or the money to beat these people." And this is not supposed to be about power and money. It's supposed to be about justice. And my child has been in this nursing home for 4 years. And every day I fear that one day I'll get a call that says she's dead because of the neglect and abuse by Child Protective Services and the family court system. And this needs to stop. They blatantly abuse their position of power. I appreciate your time, and I want this to go on the record that this needs to stop.
Hi, our time is running close to end, but we will accommodate 3 more speakers on the line at this time.
Thank you, Chair. At this time, the next speaker is Stephanie Motley.
Thank you for having me, and I can appreciate everybody's input, and I feel that this is a good thing, pulling everybody together and just have a open, honest discussion. And I think this is so needed. Quickly, my granddaughter, I'm from Virginia. My granddaughter's father lives in North Carolina. My granddaughter was living in Virginia with her mother. They had separated from the dad, and they were co-parenting together. And then some years later, when she has a severe stuttering situation, and she was in therapy and was finally able to have clear conversations with her mother, and she came forward and told her that she was being maltreated or assaulted during bath time. And so we were really taken back. She tried to reach out to the father, get information to make sure that we're not, she's not over, making sure everything was really what it was. And he refused to talk about it. And he started getting retaliation type of energy. She went to North Carolina DSS, reported it to them. They sat on the case, never did anything, sent it back to Virginia. Virginia was ready to prosecute, and then North Carolina asked for the case back when it was time to prosecute, and then the DA in North Carolina refused to do anything to him. And prior to my granddaughter, he had abused his stepson, and we had evidence of that they also let go. Had they charged him with that, it would have saved my granddaughter. So it's been 4 years, and we're still fighting to get her back from him. And each day she's with him, she's at risk. Another panelist talked about how can we do better, like how can we trust that, put trust back in the public. these are public servants. I feel that they should be publicly somehow public should be involved with the proceedings. They are abusing power in secret. They're not being held accountable, but yet they're public servants. No different. And then as far as what can we do when DSS or someone doesn't follow the guidelines and violate civil rights? Why not have a manual to give to the panel, the person that's involved, so they'll know what their rights are and what do you do when you feel that that's been violated, and they can go XYZ. Have a manual, no different than when you go into a school or college, they have a student policy book. And then the information provided in that book, the person behind it should be able to reach out to them immediately and get them some emergency help to reconsider these policies and these proceedings that they've already enacted in secret. Everything is done in secret and should be publicly shared. Transparency.
Thank you for your comments. The next speaker is Christmas Smith. Hello, Christmas.
Yes, ma'am.
Yes, you can go ahead.
My name is Christmas Smith, and I reside in Chocowinity, North Carolina, Beaufort County. And June the 1st, my son Kelly Smith coded for 20 minutes. June the 26th, my son was given the wrong formula by East Carolina Medical Center in Greene, North Carolina, Pitt County. Kelly was discharged July 4th, 2023. 2 C5 clinicians came to evaluate the home in Kelly, July the 19th, 2023. Later that night, we found a wound in the back of his head under his braid. On July 20th, Kelly was given an antibiotic without any labs done. Kelly was given an unknown amount due to the negligence of the nurse not unclamping his G-tube. July 21st, 2023, East Carolina Medical Center called DSS and stated that we left AMA when we had discharge papers. Kelly had an allergic reaction to the medicine, which caused blisters on his toe on July 22nd, 2023. July 2023, Kelly returned to the same hospital where the doctor said those marks were not an allergic reaction. CPS harassed us up until August the 1st, 2023. A teddy bear appointment was made, and a Dr. John Wright determined that rats or mice bit Kelly. August 2nd, 2023, CPS removed Kelly, along with 15 to 20 Beaufort County Sheriff officers and Chocowinity EMS, who was allowed to watch me use the bathroom in my own home. Kelly's siblings were trapped in the room as they watched. John Wright later determined his story and that roaches was the cause of the blisters. We had a Terminex person that came and inspected our home, and he stated no infestation. And the pictures we took, he saw them and stated that he has never seen any insect bite like that in all of his years of being an inspector. We have done everything DSS asked us to do, and today, July 12, 2024, we have still haven't gotten our son. The hospital and DSS has medically kidnapped our son just because we ask questions and we choose to do our research on our son. Thank you very much.
Thank you for your comments. Our last speaker for today will be Yolanda Rushing. Yolanda, are you there?
Yes, ma'am.
Okay, please get started.
Thank you. I would like to thank the panel for giving us this opportunity to come before you all to provide these public comments, and thank the North Carolina State for conducting this research and getting perspectives from live experienced families. There was a question earlier about who do you go to when you want to report something on DSS? I had that same question, ma'am. And I would tell you that in my experience, what ended up happening, we contacted our representative. They then contacted the constituent's office in North Carolina. That then turned into a nightmare. They then send you back to your county, where then you are to grieve your grievances or air your grievances to the county commissioners. But then when you email the county commissioners, they don't want to respond to you. They don't want to touch it. So then you go back to DSS and then you try to make a claim with them, but they don't want to take it. Then you got to go through the court system. But then the court system tells you you can't take no complaints. Or better yet, it goes to the district judge. But that district judge decides to recuse herself. So therefore, she backs off of it and doesn't want to touch it. Then what are you left with? I got it. You then go and seek another judge from another county to come right back in to come and do something that you could not touch. Why is that? Why did our case not have to be touched? Why can't we not find answers? So again, who is held accountable when DSS abuses our children? Because in this situation, it's not me that's been impacted. It's the children at hand that's still being impacted. But to send a parent on a merry-go-round to navigate the court system, to navigate the family court system, is a nightmare. Let me remind you, the reason why I believe these are all issues is because you're dealing with a state with 100 counties, and each county operates 100 different ways. You have high turnover rates, lack of training, and then when you have a system that's built on no accountability, the state says they can't not do anything for you. They may come in and take over, but what does that look like? We can't even get responses for that, because when you ask for the response from them to see what their investigation took, they can't disclose that information because it's quote unquote confidential. How is that information confidential? Why should the parent not know what actions were taken? It's kind of interesting. We see that actions being taken behind the scenes under disguise, but then everybody migrates and goes to other places. It's a nightmare.
Thank you, everyone, for your comments. This concludes the list of speakers for today.
I would like to thank everyone on the call, our committee members, our panelists, and our members of the public who participated today. We will continue to accept written testimony for this briefing until September 23rd, 2024. Please email written testimony and any questions regarding today's briefing to lschiller@usccr.gov. Our next panel will focus on advocate and community organization perspectives. It will take place on Wednesday, July 24th at noon Eastern Standard Time via Zoom. We hope you are all able to join. Thank you all for your time and your participation. Today's meeting is adjourned at 2:30 p.m.
Thank you, everyone.